Article 17, protecting the integrity of a person. This article begins with two comments highlighted in panels. Make inclusion a reality by ensuring everyone gets the same opportunities and disabled people do not have to fight for their rights. Ensure agencies are accountable to make this a reality. Hui participant. Ban forced drugging. Forced drugging is an abuse and a crime against another human being. Let's not complicate it. Hui participant. Introduction. Article 17 states that no one can treat a person with a disability as inferior because of their physical or mental abilities. In short, disabled people should be treated the same way as everybody else and have the right to be respected for who they are and be treated on an equal basis with others. This includes when making decisions about medical procedures and interventions affecting them directly, with the disability or impairment in no way excluding disabled people from being involved in the decision-making processes. General comment. Although generally covered by legislation, it appears that there are instances where the bodily integrity of disabled people is not protected on an equal basis with their non-disabled peers. This is of particular concern in relation to non-therapeutic medical procedures and non-therapeutic sterilization. Importance of Article 17 to disabled people in New Zealand. This article is of particular importance to those people who are least likely to be able to voice their own will and preference, with others instead making choices on their behalf. Some disabled New Zealanders are denied the opportunity to have full control over their own bodies due to substitute decision-making practices. The reality of putting supported decision-making into practice is yet to be realized, and is a concern the IMM has raised in its last two reports. Current place of Article 17 in New Zealand law and practice. Section 11 of the New Zealand Bill of Rights Act 1990 states that everyone has the right to refuse to undergo any medical treatment. However, it is still reported that non-therapeutic sterilizations and other medical procedures have taken place without the consent of the disabled child or adult. For those under 18 years, the courts do not usually need to be involved where the parents or guardians are deemed to be acting in the child's best interests. For people over 18 years old, the Protection of Personal and Property Rights Act 1988 can be used to seek court approval for sterilization without consent. Under the Contraception, Sterilization and Abortion Act 1977, non-consensual sterilization and provision of contraception to disabled people is deemed to be lawful in certain circumstances. Until very recently, an abortion could be performed without consent on women deemed to be mentally subnormal under that act. New Zealand courts have also ruled that non-consensual sterilization may lawfully be undertaken when deemed medically necessary and approved by the courts, in an emergency situation, or when approved by a person's welfare guardian to save a person's life or prevent serious harm. Compulsory treatment and solitary confinement continue to be permitted under the Mental Health, Compulsory Assessment and Treatment Act 1992 and the Intellectual Disability, Compulsory Care and Rehabilitation Act 2003. In 2016, the Ombudsman dealt with an inquiry from a disability service provider about the lack of data available around the number of involuntary sterilizations performed on women and girls with intellectual disabilities in New Zealand. The provider had attempted to obtain statistics from both the Ministry of Health and the Ministry of Justice, but was advised the information is not held by the ministries but by the courts, while reporting on sterilization procedures explicitly prohibits patient identification orders. The Ombudsman made a number of inquiries to both the Ministry of Health and the Ministry of Justice, noting that the lack of data in this area makes it difficult to monitor important disability rights for an already vulnerable population group. The Ombudsman considered that the involuntary sterilization of women and girls with intellectual disabilities in New Zealand is a matter of significant public interest, and noted that the Disability Committee, in its 2014 concluding observations, had stated that New Zealand ought to, endnote 151, Enact legislation prohibiting the use of sterilization on boys and girls with disabilities and on adults with disabilities in the absence of their prior, fully informed and free consent. The Ministry of Health and the Ministry of Justice undertook some research around the number of such orders that have taken place in the past 5 years and uncovered only a single example of the involuntary sterilization of a female with an intellectual disability. End note 152. However, the Ombudsman considered that the electronic information system for recording such information was inadequate and noted it was possible that other such orders have taken place but not been recorded. A manual review of a large number of physical files would be required to determine whether other orders took place. The Ombudsman felt this was a surprising state of affairs in 2016 when electronic data can be easily collected and analysed, end note 153, and suggested both agencies update and review their mechanisms for recording sterilisation orders. The Ombudsman reminded the Ministry of Health and the Ministry of Justice that New Zealand's Disability Action Plan 2014 to 2018 included a new priority to protect against non-therapeutic sterilisation and that there was an expectation that New Zealand passes legislation prohibiting such sterilisation altogether. The Ombudsman also reminded both agencies of Article 31 in the Disability Convention, which requires that state parties undertake to collect appropriate information, including statistical and research data, to enable them to formulate and implement policies to give effect to the Disability Convention. Action Item 7B of the New Zealand Disability Action Plan 2014 to 2018 was to explore the framework that protects the bodily integrity of disabled children and disabled adults against non-therapeutic medical procedures, including the issue of consent. The initial focus was to be on options to protect against non-therapeutic sterilisation without the consent of the individual. Despite a project reference group being set up in 2018 to discuss the action item, the IMM believes progress on this initiative has stalled. The IMM considers it essential that the government responds to the updated Disability Action Plan 2019 to 2023 by ensuring that this action is completed as a first step to preventing further involuntary sterilizations. Committee's previous dialogue with the state on Article 17. The government's first report to the Disability Committee explained the exceptional circumstances in which treatment may be given. In its response, the Disability Committee requested data about the number of sterilizations carried out on women and girls with intellectual disabilities without their consent. The government reported that while information on sterilisation is collected, it does not include information about whether the patient is disabled. Questions asked in the current reporting cycle include the measures that have been taken to enact legislation prohibiting non-consensual treatment, including sterilisation, with particular attention to disabled children. The response outlined the legal framework under which non-consensual treatment may be undertaken. The Disability Committee also asked about the practice of Ashley treatment or growth attenuation procedures. The response stated the legality of the use of Ashley treatment has not been fully tested in the New Zealand Family Court, end note 154, and the extent of its use is unknown but deemed to be rare. They confirmed that people who have been subject to this treatment overseas are able to receive medical care in New Zealand on an equal basis with others. There is at least one confirmed instance of a New Zealand child being subjected to Ashley treatment overseas. End note 155. Comment on the realisation of Article 17 in New Zealand. Although concerns remain about the possible practice of involuntary sterilisation, particularly of disabled girls and women, there is no robust data available on the prevalence of this practice. Work is planned to involve government and disabled people's organisations in finding ways to address this issue and to protect disabled people from non-therapeutic sterilisation without the full consent of the individual. The Law Commission has an upcoming programme of work to review laws related to adults with impaired decision-making capacity. Hundreds of people continue to be subject to compulsory assessment and treatment, seclusion and electroconvulsive therapy under the Mental Health Compulsory Assessment and Treatment Act 1992 and the Intellectual Disability Compulsory Care and Rehabilitation Act 2013, end note 156. Forced medication can be regarded as a threat to mental integrity. Participants at the IMM consultation hui were particularly vocal in their aversion to the use of seclusion or restraint and the many forms these take on, with one participant saying, "Stop it, no more, put it on a t-shirt." Recommendations. The IMM recommends that the government 45. Enact legislation to prohibit the use of sterilisation or any other non-therapeutic medical procedure on disabled children and disabled adults without their prior, fully informed and free consent. 46. Improve methods of collecting and reporting on statistics on sterilisation and other non-therapeutic medical procedures in New Zealand, whilst ensuring all data collection is anonymised in such a way to prevent identification.